Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is from our Curious Lawyer series and is a program that looks at the idea of secession. Is it clearly unconstitutional? Is it more murky? Do states have the right to vote to leave the United States? Are we seeing judicial opinions from states even start to fire shots at the federal state system? We ask ultimately, does our Constitution actually properly address this, and what are the arguments on each side of the ledger here? We will not make any political statements or pronouncements. This program always gives you just the straight facts on the law. We will simply outline the arguments on each side so that your curiosity about this area of law can be fulfilled. In this current political climate, where more and more talk occurs in the press and within states on each side of the red-blue divide about the idea of secession, this program will let you, the curious lawyer, have all the facts so that when you are at your next cocktail party and someone asks, you can tell them the law as it relates to secession. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So, sit back and let's get going in our fascinating and I hope eye-opening exploration of secession within our constitutional and legal framework. Let's start with our agenda today in terms of what we will be looking at. The overarching question we are asking, of course, is whether secession is constitutional within our legal framework. What does the Constitution itself say about this? And as we double-click, what do some amendments say about it, specifically the 10th and 14th Amendments, we will look at in terms of how they may help answer the question. We will also look at what the Supreme Court of the United States has said in a case called Texas versus White, which came down after the Civil War. That will require an interesting look at that split decision, and what that means today in terms of the constitutionality of attempted acts of secession by states. The Alaska Supreme Court also looked at this in the year 2000, when there was a movement afoot in Alaska to try to get a ballot placed before the voters to achieve secession. Ultimately, we will spend some time looking at the arguments on each side of the constitutionality question. As a heads up, it is not a slam dunk that it is unconstitutional, which is where most of us were after we may have read the Texas versus White case from law school or have heard about it. It turns out there may be an opening in that door from that case itself. This will lead us to look at a couple of preeminent legal scholars' works in this area. We will look at Erwin Chemerinsky, the dean of the Berkeley School of Law, and perhaps the most renowned legal scholar in America, and his 2024 book called No Democracy Lasts Forever: How the Constitution Threatens the United States, as in that book, he addresses and talks about this question of secession and its grounding. We will also look at a book from Cynthia Nicolette, a professor of law at the University of Virginia. Her book is called Secession on Trial: The Treason Prosecution of Jefferson Davis, and it is a fascinating look at a lengthy legal battle against Confederate President Jefferson Davis after the Civil War, and the concerns in that case in terms of the prosecution of him for treason, which triggered questions about whether the state had lawfully withdrew or not from the Union. We will look at the shadow perhaps that casts in terms of the questions we ask today. And we will look at a fun case from the Hawaii Supreme Court in 2024, which arguably is a firing shot against the federal regime, at least within the court system, where the Supreme Court of Hawaii has at some level told the United States Supreme Court that it doesn't care about the U.S. Supreme Court, Second Amendment jurisprudence, and Hawaii will follow its own rules and its own history on gun legislation and regulation. Now, while that is not a state withdrawing from the Union, it is certainly a massively significant opinion in terms of a state court, simply telling its federal counterpart, at least within the judicial branch of our government, that it is not willing to play ball anymore. Those judicial breakdowns are not part of our history, and so this is a new development too, that fits into our overall picture of ever-growing fractures between the states and the federal government. This, of course, is a very difficult topic. It exists in some legal discourse over the last 10 to 15 or 20 years, but it has been very small and tiny corners of the legal academy. But it is a growing issue, and Erwin Chemerinsky's 2024 book, which is not a narrow niche legal publication, but is a narrative nonfiction book that has been quite popular itself with general readers, discusses this issue and the question of the constitutionality of it. In fact, it is a very moving part of his book that he discusses how hard it is to even spend time thinking about and writing about and assessing the constitutionality of this question, given the gravity of it and our normal operating principles that revolve around the Constitution. But it is something that needs to be discussed, given the growing issues in society, and I think he is right, and his book is well worth reading in my opinion, and so that is why we have this Curious Lawyer program for you. There is data here that matters, and we can look on our bullet points here on the slide, and if you look at the indented bullet points, and the last one, as you can see, and you may know Hawaii and Alaska since the 1970s have had very, very small movements wanting to achieve secession, but they were tiny. Now, Vermont, California, and Texas in just the last 10 to 15 years themselves formed official parties and had growing sizable groups of people now actually openly discussing this and wanting to address this at a statewide level. In Texas, we have the Texas Nationalist Movement, known as TNM, and TNM basically is built on the idea that Texas was an independent republic before it joined the United States in 1845, and that coupled with dissatisfaction with the current state of affairs on the relationship between the state and federal government has led it to officially be created in 2005. As of 2019 to 20, some polls show it having support of 17 to 20% of the population. So you can see this is not just a fringe 1% type thing. California, of course, is a blue state in distinction to Texas being more of a red state. And so in California in 2015, an organization was formed that is called Cal Exit, a play on, of course, Brexit, the Great Britain did, in terms of exiting and withdrawing itself from the European Union. Cal exit started growing after the 2016 presidential election, and the advocates for it argued that California's political, economic, and cultural values simply diverge from federal policies. And at least in 2016, around the time of the presidential election, polls showed 30 to 40% of California and supported this. Now, of course, recall 2016 was a very heated election between Hillary Clinton and President Trump, where Hillary Clinton won the popular vote but lost the Electoral College vote. And that could, of course, explain numbers polling that high. But for our purposes, what is important is that this issue is one that must now be discussed and understood within our legal framework, within our Constitution, because it is becoming more mainstream a question. And you, the curious lawyer, need to know the legal answers to these questions when asked. Therefore, from a legal perspective, we can start with Erwin Chemerinsky's 2024 book, No Democracy Lasts Forever, because he discusses the generally understood belief that it is per se unconstitutional, case closed. And he notes that it is actually not that clear a question, even within the decision of the United States Supreme Court from the 1860s. We will get to that soon, but let's start first with the Constitution itself and take a look at what it says about these questions. Let's take a look now at the Constitution itself. First, the most important framing principle here, the Constitution says nothing one way or another expressly about this issue. It is simply silent as to the existence of secession an issue. But arguments have been made about various parts of both the Constitution and also the Bill of Rights and subsequent Civil War amendments, which we will now look at to forensically assess whether there are implied arguments one can make on either side of the equation from various provisions in the Constitution. Let's start with the preamble, which says, of course, quote, in order to form a more perfect union, end quote. That basic language of the preamble of the Constitution creates the argument against secession based on the idea that we have a union and a union cannot exist if it can be broken. And so therefore, the idea of creating a more perfect union necessarily means that those who join it grant sovereignty to the union that is non-rescindable. The counter-argument is well put by Erwin Chemerinsky in his book, and he says, quote, it stretches beyond credulity to say that the preamble's commitment to a more perfect union implicitly prohibits states from seceding. A couple's promise to marry and pledge to spend a life together doesn't foreclose that things later can go sour and they might divorce, end quote. The second major area we can look at relates to the grants of national powers in the Constitution to the federal government. For example, multiple provisions give the federal government exclusive control in certain domains, such as interstate commerce, the power to coin, money, bankruptcy, the power to make war and peace, and further, the Supremacy Clause makes federal law supreme. The argument against secession here goes as follows, and that is that these national powers by definition imply an organizational structure that has granted authority to a higher power to which you cannot leave. The counter, of course, is that it simply implies who is in control when both are together, and that does not deny the one the right to leave and then do those things separately. Then finally, there is the fact that where we started the slide, there is nothing express. But what does that mean? The argument against secession says that there were heavy debates about entering the Constitution itself, and that silence shows that the issue was seen as a permanent joining, especially given the full term out of which the states finally agreed to join in this effort. The counter-argument is that the framers actually knew well how to impose specific limits on states such as an article. One Section 10 that forbids states to make money or enter treaties. That shows that if the federal government wanted to expressly forbid something, then it knows exactly how to do that. The absence of such an express preclusion of secession therefore means that it was not expressly precluded, and not imply precluded either. As to the actual discussion by the founders, Berkeley law professor Dan Farber notes in his works here that there are very limited statements in the debates, and they, quote, are hard to interpret. They might have referred to a legal right to revoke ratification. But they equally could have referred to an extra-constitutional right of revolution, or to the possibility that a new national convention would rewrite the Constitution, or simply to the factual possibility that the national government might break down, end quote. And there you have a reference citation to his book and page number for that. The point being, we cannot discern any clear framer's intent to form their debates. This has taken us through the Constitution, but let's now look at the Bill of Rights, and specifically the 10th Amendment, to assess what this amendment may mean on this question. The Constitution, of course, was signed in 1787 and began operating in 1789. 2 years later than 1791, the Bill of Rights was ratified. This is where we are now going to look at those amendments to the Constitution, specifically the 10th Amendment. Let's start with the 10th Amendment language itself. It says, quote, "The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, or reserved to the states, respectively, or to the people," end quote. What does this amendment language then mean with respect to our secession question? Does it mean that because the power of leaving or not being allowed to leave was not expressly delegated to the U.S. government nationally to decide, therefore it is reserved to the states and they absolutely have the right to do it? This will require a little trip down our 10th Amendment jurisprudence, where we will do a quick recap of a few key cases and principles since the founding. Of course, if you want more detail on the 10th Amendment, or any of the other first 10 amendments, we have a Curious Lawyer series with 1 hour devoted to each of the first 10 amendments to the U.S. Constitution, so you can go watch all 10 episodes of the Curious Lawyer Bill of Rights series to learn all about the first 10 amendments. Before we get into some of the cases, let's take a look at Justice O'Connor's speech that she gave discussing the 10th Amendment and its significance to the federalism principles that sit within our system. She actually referred to it as the battle scene of federalism. I have a citation here to her full speech where you can watch it if you want, which is available on YouTube, but I'm going to play a short audio clip for you now where you can listen to her discuss this battle scene of federalism and what it may portend for this discussion we are having here today. Of course, in her speech and in that discussion, she is not talking about the issue we are discussing with respect to secession, but the shadow that is cast by our understanding of the 10th Amendment could be significant to the question. Let's now take a listen to her.
But the framers did not think it would be enough simply to place state hands on the central tiller. The framers instead provided that the central government would be one of limited, enumerated powers, with the states retaining those powers that were not delegated upward. At the same time, the Constitution forbade the states from exercising certain powers that would rest in the central government alone. These principles are the primary fulcrum on which the ultimate balance between state authority and national power rests in my country. The limitation of the central government's authority is inherent in our constitutional design. The 10th Amendment to our Constitution, ratified in 1791, reinforces this design by stating that famous truism, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." The framers of our Constitution then established dual spheres of sovereignty, allowing the central government to act directly on individuals in some fields of activity, while preserving the sovereignty of the states acting within their own territorial boundaries. Today's central government certainly does not resemble the limited enterprise that the framers of our Constitution envisioned. While some of the expansion is a result of formal constitutional amendments, our country's response to technological and social change accounts for the lion's share of the growth of central power. The framers could not have foreseen our world of technological sophistication and mass communication. They could not have known the internet, the 747, or biotech corn any more than they could have envisioned cable television, cloning, or the splitting of the atom. And that is to say nothing of Starbucks, of Napster, or the weakest link. Chiefly through Congress's exercise of its powers under the Commerce and Spending Clauses, aided by broad judicial interpretations, the sphere of federal activity in my country has greatly expanded.
Let's now take a look at this battle scene of federalism across a few cases within the 10th Amendment area so we can see how it has evolved and changed over time in terms of the meaning of that language. We will start, of course, with one of the most famous cases from the Supreme Court, McCulloch versus Maryland. This case, of course you will remember from law school, is one that involved the situation of Congress creating a national bank and then the state of Maryland taxing the bank. This led to litigation, raising the issue of whether Congress had the authority to create a national bank and whether the state of Maryland then interfered with an area that belonged to the federal government. So the question it raised was, how do we interpret the exclusive federal powers as they were late to the remainder of the area that would belong to the states? This case thus involved the power of Congress to charter a bank, which sparked the even broader issue of the division of powers between state and the federal government. And here is the quote from the case. Quote, "Even the 10th Amendment, which was framed for the purpose of quieting the excessive jealousies which had been excited, omit the word expressly and declares only that the powers not delegated to the United States, nor prohibited to the states, are reserved to the state, or to the people, thus leaving the question whether the particular power, which may become the subject of contest, has been delegated to the one government, or prohibited to the other." End quote. The result of the case is that the court took an expensive interpretation of the necessary, improper clause, and so, as a result, the taxation power included the act of making a bank, and this created an expensive scope of federal power. And the result then was the state cannot tax federal notes because of the scope of the federal power. This is a critical federalism moment where, by the court ultimately held, that even though states have taxation power, they cannot do so in a manner that interferes with the supreme law of the United States. This case held that the federal government in this area had sovereign power over the states. Now let's move to 1941, and we will consider the case of United States versus Darby. It is reported at 312 U.S. 100. Here, Congress adopted the Fair Labor Standards Act, and it required minimum wages and maximum hours for employees engaged in the production of goods that touch interstate commerce. The 10th Amendment challenge was brought to these Fair Labor Act requirements. The argument was that it exceeded Congress's power to mandate minimum wages and maximum hours. You can see here the quote that the Supreme Court held, noting that the motive and purpose of these laws was to affect Congress's interstate commerce powers, to which the federal government is not subjected to limits. As a result, it was held that there was no 10th Amendment violation. For our purposes, what is important is this bold language you can see here which says, "The amendment states, but a tourism that all is retained, which has not been surrendered." This becomes an important bedrock of the 10th Amendment in terms of whether it has substantive teeth or whether it is simply a truism to which you cannot divine scope and substance. Quote, "There is nothing in the history of its adoption to suggest that it was more than declaratory of the relationship between the national and state governments as it had been established by the Constitution before the amendment, or that its purpose was other than to allay fears that the new national government might seek to exercise powers not granted, and that the states might not be able to exercise fully their reserved powers. From the beginning, and for many years, the amendment has been construed as not depriving the national government of authority to resort to all means for the exercise of a granted power, which are appropriate and plainly adapted to the permitted end." End quote. Now we will look at two more cases where there was a massive shift in the Supreme Court within a decade on its 10th Amendment jurisprudence. The first is from 1976, and this involved a federal law that extended minimum wage protection to state and municipal employees. Now, various states challenge these laws as interfering with the traditional employer and employee relationship between a state and its workers, and argued that this exceeded Congress's power under the Commerce Clause. Although the court recognized that the Commerce Clause authorized minimum wage laws covering most employees, the court held that the Constitution's structure and the 10th Amendment's recognition of the role of states in the federal structure prohibited the federal government from telling states what they must pay their own employees. The Supreme Court held, quote, "This court has never doubted that there are limits upon the power of Congress to override state sovereignty, even when exercising its otherwise plenary powers to tax or to regulate commerce. While the 10th Amendment has been characterized as a truism, it is not without significance. The amendment expressly declares the constitutional policy that Congress may not exercise power in a fashion that impairs the state's integrity or their ability to function effectively in a federal system." End quote. As a result, the law was struck down, and the 10th Amendment actually stood as a limiting principle against an overexpansive interpretation of the Commerce Clause, and so here states' rights won in this federalism battle. This is important because it marks a shift between the idea that the amendment simply states a declaratory truism, and this time, the amendment actually formed a limiting principle on the reach of federal power. For our question of secession, you can obviously see where this is going, in terms of whether the 10th Amendment would function similarly. But in a remarkable switch in time in less than a decade, let's see what happened in the 1980s. The Supreme Court roster of justices had not changed by 1985, but one of them certainly had a different viewpoint of the national case from 1976. This brings us to the Garcia case from 1985. The issue here was whether the local transit authority that received federal funds was immune from federal minimum wage hours and requirements. The district court followed that 1976 national case and held that the laws cannot be applied. The case went up to the U.S. Supreme Court, however, and this time Justice Blackmun switched his vote, and so as a result, that 1970 Sykes National League of Cities versus U.S. case was reversed. This time, the court held that the federal law did not damage state sovereignty. There was a vigorous dissent, which noted that given the switch in the last decade, the decision had essentially reduced the 10th Amendment to a meaningless slogan in essence when Congress acts under the Commerce Clause, which becomes infinitely elastic. You can see here the quote from the dissent. Despite some genuflecting in the court's opinion to the concept of federalism, today's decision effectively reduces the 10th Amendment to meaningless rhetoric when Congress acts pursuant to the Commerce Clause. In our federal system, the states have a major role that cannot be preempted by the national government. As contemporaneous writings and the debates at the ratifying conventions make clear, the states' ratification of the Constitution was predicated on this understanding of federalism. Indeed, the 10th Amendment was adopted specifically to ensure that the important role promised the states by the proponents of the Constitution was realized. End quote. This then essentially limited the 10th Amendment. As a fascinating aside, we can see here an interview snippet with Justice Blackmun on his switch. I won't read it all to you, but you have it here to read. And this is the interesting part on his idea that it is better that wisdom comes late rather than never at all. Quote, "But I went along with it at that time. And of course, I suspect that when the other case came up, the Garcia against the San Antonio transit system, perhaps by that time, I had become a little more conscious of what it was, in effect, a federal-state controversy, as to whether the federal rules should prevail over the state. And of course, I've had criticism on that. I don't feel that I jumped the gun. I may have changed my mind. Some commentators have said this was a struggle for Blackmun's mind, is what it was, because I was the swing vote in both of them. Potter Stewart at one time said that, and this is in a writing, in one of his short concurrences, that it's better that wisdom comes late than not at all, end quote. So where this leaves us before we get ready to turn to the Supreme Court and the Civil War is that the Constitution does not expressly address the issue of secession one way or another. The 10th Amendment could be used to argue that given the absence of an express reservation of that right to the federal government, it is implicitly left to the states to be able to leave. But the 10th Amendment also has been limited over time in terms of having substantive teeth, and may be more of simply a declaratory truism that there is a balance that has to be figured out. In that sense, it would not be a tool that could be used to discern the answer to our question. Or if it is a tool, it would not be definitive in terms of the answer. Let's now turn to the Supreme Court and the Civil War fallout on this question. This brings us to the case of Texas versus White from 1868. Here are the basic facts you need to know. In 1851, Congress authorized the transfer of $10 million worth of U.S. bonds to the state of Texas. During the Civil War, Texas, under its Confederate government, sold them. After the Civil War, the Reconstruction government claimed that the bonds had been illegally sold by the Confederate state legislature during the Civil War, and they wanted them back by arguing that the sales contract had to be annulled. The issue, of course, this raised is whether Texas remained a state, even though it had joined the Confederacy. You can see here the issue is framed by the Supreme Court in light of Texas's arguments to void the contract. The Supreme Court framed the issue as, quote, "If, therefore, it is true that the state of Texas was not at the time of filing this bill, or is not now, one of the United States, we have no jurisdiction of this suit, and it is our duty to dismiss it. We are very sensible of the magnitude and importance of this question, of the interest it excites, and of the difficulty, not to say impossibility, of so disposing of it as to satisfy the conflicting judgments of men equally enlightened, equally upright, and equally patriotic." End quote. It then defined a state as, quote, "In the Constitution, the term state most frequently expresses the combined idea just noticed of people, territory, and government. A state, in the ordinary sense of the Constitution, is a political community of free citizens, occupying a territory of defined boundaries and organized under a government sanctioned and limited by a written constitution and established by the consent of the governed. It is the union of such states under a common constitution which forms the distinct and greater political unit, which that constitution designates as the United States, and makes of the people and states which compose it one people and one country." End quote. So the question this raised was whether Texas ceased to be a state when it left the Union and joined the Confederacy. If it did cease to be a state because secession was lawful, then there would be no jurisdiction to revisit the bond sale. Here is the rule the court quickly dated after framing the issue as the way you can see. Quote, "The union of the states never was a purely artificial and arbitrary relation. It began among the colonies and grew out of common origin, mutual sympathies, kindred principles, similar interests, and geographical relations. It was confirmed and strengthened by the necessities of war, and received definite form and character and sanction from the Articles of Confederation. By these, the Union was solemnly declared to be perpetual. And when these articles were found to be inadequate to the exigencies of the country, the Constitution was ordained to form a more perfect union. It is difficult to convey the idea of indissoluble unity more clearly than by these words. What can be indissoluble if a perpetual union, made more perfect, is not? But the perpetuity and indissolubility of the union by no means implies the loss of distinct and individual existence, or of the right of self-government by the states." End quote. As a result, the court held in a split opinion that Texas had standing to try to bring the suit to void the contract, and the court noted that the Texas legislature's actions were absolutely null. You can see from the language in this case where the long-standing understanding has been that it is simply unconstitutional for a state to leave. Here the Supreme Court majority indicated that in order to form a more perfect union, this political unity was permanent. Now remember, the decision was split 5-3, so it was not exactly a slam dunk one way. Here is what the dissenting justice wrote, quote, The Ordinance of Secession was adopted by the Convention on the 18th of February, 1861, submitted to a vote of the people, and ratified by an overwhelming majority. I admit that this was a very ill-advised measure. Still, it was the sovereign act of a sovereign state, and the verdict on the trial of this question, by battle, as to her right to secede, has been against her." End quote. In other words, what this justice and the ones who joined him said was that the act of Texas was lawful in leaving. It may have been an ill-advised and bad decision, but it became a sovereign state as a result of voting to secede. This means it actually had the right to leave, and so the idea of the majority as it related to a permanent union was not agreed to by these members. The justice saw a certain hypocrisy in the new argument Texas was advancing. Quote, "She cannot, like the chameleon, assume the color of the object to which she adheres, and ask this court to involve itself in the contradictory positions that she is a state in the Union, and was never out of it, and yet not a state at all for 4 years, during which she acted and claims to be an organized political body, exercising all the powers and functions of an independent sovereign state." End quote. But the chameleon prevailed, and this case has long stood as being seen as per se making secession unconstitutional. But is there actually an opening for this opinion itself? Here is what Dean Erwin Chemerinsky has argued in his book. Quote, "The case is always cited to support the proposition that secession is unconstitutional, but actually the decision is more equivocal than that, and indeed actually recognizes the permissibility of secession under the Constitution." End quote. Why does he write that in his No Democracy Lasts Forever book? Because there is a portion of the opinion that is not paid attention to by those who argue it is a bright line rule case. Specifically, it says the union between Texas and the other states was as complete, as perpetual, and as indissoluble as the union between the original states. There was no place for reconsideration or revocation, except through revolution or through consent of the states. That language that is bolded there gives an escape hatch for a state, and does indicate that revolution or consent of the states would be a basis to secede. But what is the scope of that language? Does it require a national revolution equivalent to the one that formed this country? That would not seem to make sense, since he was talking about the right of his state to leave. But in that sense, there was a revolution by all the states that left to form the Confederate States of America. And he notes that consent of the states could authorize it, but again, Texas voted in its legislature to secede, so consent did exist. This language's scope and meaning is certainly mystifying, but it certainly does open the door, as Professor Chemerinsky notes, to the idea that the rule of secession being unconstitutional is not as per se as we may have believed. Here's what he writes in his book about this issue. Quote, "Secession was occasionally mentioned in the state ratifying debates, but those discussions offer no clear conclusions. As my colleague Berkeley law professor Dan Farber notes, the scattered statements made there about the impermanence of the Union are hard to interpret. They might have referred to a legal right to revoke ratification, but they equally could have referred to an extra-constitutional right of revolution, or to the possibility that a new national convention would rewrite the Constitution, or simply to the factual possibility that the national government might break down." End quote. In other words, this issue is not a bright line, clear Rule 1. After all, as he notes in his book, quote, "If the framers meant to forbid it, they could have said so. They imposed other limits on state government power. For example, Article 1, Section 10 forbids states to enter into treaties or coin money or interfere with the obligation of contracts. The framers could have expressly prohibited states from seceding, or they might have added a prohibition of secession to Article 7, which specifies how the Constitution would be deemed ratified." End quote. Again, I think Dean Erwin Chemerinsky's book, No Democracy Lasts Forever, is a really good read. So as a plug for that book, I would recommend you read it. And this will bring us now to another book that I also think is well worth reading on our odyssey through the law as it relates to secession. Now let's turn to another law professor, Cynthia Nicoletti, and her fantastic book called Secession on Trial: The Treason Prosecution of Jefferson Davis. This is a fascinating and incredible read, with a look at the arrest for treason of Confederate President Davis after the end of the Civil War, and the charge against him for leading the seceding states. But as she notes through her deep research into the history of the litigation and the lawyers and the case being fought, his case never went to trial. Why is that? As she argues in her book, the U.S. government was concerned that trying him for treason required him to be a U.S. citizen, but when his state left, he was no longer a U.S. citizen. So the case raised the question of how he could be guilty of treason. After all, foreigners may commit crimes here, but treason is not one of them, since they are not citizens. The defense argument in this case, which ended up in civil court as opposed to criminal or a military tribunal court, was to argue and convince a jury that the act of secession was legal and therefore he could not be guilty of treason. The federal government was sufficiently concerned about this, specifically a jury actually acquitting him, that they ultimately dropped the case without risking a trial on the merits of that question. This is immensely important to our analysis here because it shows deep concern within the government at the end of the Civil War about that question, as to whether it was legal or not to secede within the Constitution. Here is a quote from Professor Nicoletti discussing her book, and you can read her entire interview at the link there on the University of Virginia or law school's website. She says, quote, "I don't take a position. It's really important for me to treat it as a question that can go either way." I think that might be surprising to a reader, because today talking about the legality of secession seems so far-fetched, but I want to introduce them to the arguments on both sides. And there wasn't a clear answer one way or another. This is a place where the Constitution is silent. So as you can see, we have another preeminent legal scholar noting that this is not a slam-dunk act that is illegal, and there are arguments on each side. The Constitution's silence is pretty powerful, as she notes. So, as it stands, we have looked at the Constitution, the 10th Amendment, and two preeminent national legal scholars on this question. And we can stand this far in our inquiry with the following conclusions. First, the Constitution does not say anything expressly one way or another about it. Second, the 10th Amendment is unclear in scope and meaning as to whether, given the absence of a state having the right to secede or being denied the right to secede, the 10th Amendment would fill the void and grant that right. And we have a Supreme Court case which said Texas was in a permanent union for purposes of resolving a bond ownership contract dispute. But that was with a vigorous dissent, and the majority itself had language that indicated that this permanent union may not be so permanent. We also have the reality that that case from the Supreme Court was decided in the 1860s, where women often lacked the right to even divorce their husbands, because marriage was essentially deemed permanent also. In the modern world where we have no-fault divorce, the idea that any two people or entities or corporations could come together but literally never separate is itself, at least at 30,000 feet, atypical to say the least. But now let's look at the 14th Amendment, and we will talk about what it may say on this question, where another legal scholar, one that Erwin Chemerinsky referenced in some of his quotes above, as you may have noted, has come to a different conclusion as it relates to the 14th Amendment and how the 14th Amendment may affect this question. Here is the language of the 14th Amendment, Section 1 on citizenship. And the question we will be asking is whether this 14th Amendment's language implicitly rejects the right of a state to secede. First, all people born or naturalized in the United States are citizens of the United States and the state they reside in. Second, no state can make or enforce any law that abridges the privileges or immunities of citizens. So what is the argument that Professor Farber makes here? The argument is that because federal citizenship is by birth in a state, and state citizenship is therefore derivative, the state cannot control or limit federal citizenship by eliminating a federal citizen from the equation, which would happen if a state left. That is, if a state leaves it, would deny that federal citizen their privileges and immunities of their federal citizenship in violation of the 14th Amendment. Now, the counter-argument would be that the Privileges and Immunities Clause is meant to stop interstate discrimination against other state citizens, and that has nothing to do with the act of a state seceding from the Union. At the same time, people can have dual citizenship, and they are not actually stripped of their federal citizenship. If a state leaves, they can retain their federal citizenship and go to another state that is still within the Union to retain those benefits. Much like dual citizens of two countries get varying benefits depending upon exactly where they choose to live. But the professor's argument is significant because this would be an amendment enacted after the Civil War, which would drastically change the calculus in light of the way it defined citizenship and the act then of secession. If it interferes and damages that citizenship right would arguably be in violation of the Privileges or Immunities Clause. The structural argument, then, is that this implies secession is not constitutional. So what has happened in the subsequent decades? And this brings us to Alaska in the year 2010. Here the plaintiff proposed a ballot initiative to put on the Alaska state ballot where citizens could vote on secession. He received the requisite number of signatures to have the ballot placed on an election cycle, but the governor declined to certify the initiative and have it placed to voters. The case was litigated to the Alaska Supreme Court. Here is what the Alaska Supreme Court held. While a state's ability to secede was an unsettled question before the end of the Civil War, subsequent United States Supreme Court opinions have concluded that secession is clearly unconstitutional, and Lincoln's belief in a perpetual union is reflected in what we have described as a plenitude of Supreme Court cases holding as completely null the acts of secession by Confederate states. His is the law to which we Alaskans bound ourselves at the moment we achieved statehood." End quote. So there you have the highest court of Alaska, at least citing Texas versus White, for the proposition that this is a permanent union of all states. Now, the court did not deal with that language we have looked at. It did not even mention it, or address it actually. So we don't know how a court, if confronted with that language that arguably implies a right, would manage it. But we do know there is a strong inkling of states not to permit this, or at least not to allow it to be done by a ballot initiative outside the legislative process. Now let's move from Alaska to Hawaii. Now we will look at a fascinating Supreme Court case from Hawaii, which is not an act of a state leaving the Union, but it is a definite similar issue in terms of a state court essentially rejecting the higher U.S. Supreme Court's law on the Second Amendment. So it is an example, at least, of state courts reaching a point of frustration with their federal counterparts and simply defying and not wanting to be a part of the judicial system and the structure we have, at least as it relates to the Second Amendment. So let's take a look at this case. Here we had a police report of people on private property, and the owner showed up with his gun to detain the defendant. The police arrive, and the defendant volunteers that he has a gun on him, which leads to his arrest. Now, in seeking to dismiss the criminal prosecution for the unlawful possession of a gun which he had for self-defense, he argued, he took the position that this U.S. Supreme Court's most recent significant Second Amendment decisions gave him an express private right to keep and bear arms for self-defense. If you want to get a full rundown on those Supreme Court cases, check out our Curious Lawyer Bill of Rights series, and you can watch the Second Amendment 1 to get the ins and outs of the Second Amendment jurisprudence as it currently stands today. Now, the court was not amused and used this as an opportunity to challenge the U.S. Supreme Court decision in Bruin, which is the current seminal one that has recognized the Second Amendment as giving a private individual right to have guns. Here is what the Hawaii Supreme Court said. Quote, "Bruin unravels durable law. No longer are there the levels of scrutiny and public safety balancing tests long used by our nation's courts to evaluate firearms laws. Instead, the court ad-libs a history-only standard, time traveling to 1791 or 1868 to collar how a state regulates lethal weapons, per the Constitution's democratic design, is a dangerous way to look at the federal Constitution. As the world turns, it makes no sense for contemporary society to pledge allegiance to the founding era's culture, realities, laws, and understanding of the Constitution." End quote. The court then invokes heavily the Hawaiian history pre-America, when it was its own kingdom. Quote, "In Hawaii, the aloha spirit inspires constitutional interpretation. The spirit of aloha clashes with a federally mandated lifestyle that lets citizens walk around with deadly weapons during day-to-day activities." End quote. Thus, its core holding is literally this. Quote, "Article 1, Section 17 of the Hawaii Constitution mirrors the Second Amendment to the United States Constitution." We read those words differently than the current United States Supreme Court. We hold that in Hawaii there is no state constitutional right to carry a firearm in public. End quote. Now that is a pretty aggressive and bold statement, and it directly challenges the federal authority, at least within the judicial branch structure we have. It's not secession, but it is a sort of judicial branch intersecession, at least within the Second Amendment. And the larger point it gets to is the growing fractures between our states and federal government, either as a whole or even within branches like this. So let's now do a recap on these next couple of slides, where we will look at the arguments on each side of the ledger here. Let's start with the overview of arguments that support the idea that there is a right to secede. There are 4 major arguments that we can distill from our program today, and they are laid out as follows. First, the right to self-determination. Supporters argue that secession aligns with the principle of self-determination, allowing a population to decide its own political status. This is a foundational idea in many democratic systems and has been a key justification for independence movements worldwide. This idea means that a cornerstone of democracy is that you can stay or go and cannot be permanently bound to anyone. Second, the compact theory. This theory suggests that the United States was formed by a voluntary compact among states. Therefore, if states voluntarily entered the Union, they should theoretically have the right to leave it, particularly if they believe the federal government no longer represents their interests or violates the original terms. Third, and related to this second point, we have the idea of constitutional silence. The U.S. Constitution does not explicitly address the right to secession. Some argue that because secession is not forbidden, states retain this right under the 10th Amendment, which reserves powers not explicitly granted to the federal government to the states or the people. Moreover, the Constitution knew how to expressly forbid states from doing certain things and did so in certain circumstances. The absence of denying a state the right to secede in light of those other commands implies that the right was retained by the states. And as we saw, there is an argument that the very case that held Texas was part of a permanent union actually also indicated there is not so permanent a connection. You will remember there the quote we had from the decision, as noted by Professor Chemerinsky. Finally, there is the idea of historical precedent and tradition that sits beneath all this. The United States was born out of a revolutionary break from Britain, rejecting rule by a government perceived as oppressive. Secession, thus, is a legitimate remedy that must always be on the table. It was so obviously present that no one needed to address it, the argument goes. Now let's look at the other side of the ledger, and we will address the arguments that stand against there being a right to secede within our Constitution. First, we have the idea that there is permanence of the Union. Specifically, Texas v. White noted, quote, "an indestructible union of indestructible states," end quote. This arguably supports the idea that states cannot unilaterally secede, as joining the Union created a permanent and binding relationship. And the argument would further go that the language we looked at that indicated with consent or by revolution one could leave cannot engraft in ways that proponents of secession would want, because those conditions would have been met in the Texas case anyway. Second, supremacy of the federal government. Article 6 of the Constitution establishes that federal law is the supreme law of the land, suggesting that states are subordinate to federal authority. Advocates against secession argue that because states do not possess sovereignty in the same way independent nations do, they cannot unilaterally dissolve their relationship with the Union. The 10th Amendment does not operate as a barrier, because it is a truism of the relationship, but not a substantive principle that can be applied. Third, of course, potential for anarchy is itself a counter-argument. Secession could lead to instability and frequent fragmentation. This would hinder national unity, weaken international standing, and compromise economic and military power. Thus, allowing secession could create a precedent that destabilizes the United States. Fourth, we have Civil War precedent. That is, the Civil War established a powerful historical and practical precedent against secession. After all, when states seceded, there was a war, and they were brought back. They were not just allowed to leave and be their own new nation. Many view the outcome of the war as a definitive resolution on the issue, where the preservation of the Union was solidified through military and political means. Finally, constitutional structure is seen as actually denying a right to secede. That is, the absence of such a potent right means it does not exist, and it was so well understood that in the heavy debates about even having a constitution, the implicit bargain was that states would forever give up that right by entering the compact. And related here, the argument would further add that the 14th Amendment implicitly denies such a right to secede given the amendment's citizenship language and structure. So this brings us to the end of our program today, on the issue of whether states can secede from the Union within our Constitution, or whether the act of secession would be unconstitutional. Let's recap our conclusions for today, so that you, the curious lawyer, can now be armed with all this information to discuss with your friends and family members, or at cocktail parties, when you are inevitably asked about what is going on in the country, and whether states can do this. First, the Constitution itself is actually silent on this issue as an express matter. And so, as you saw, there are multiple arguments that can be made that go either way in terms of the significance of the silence. On the one, and the silence can indicate that there is no such right, in light of the fact that when Congress wanted to limit states' right to do something, it did so expressly and so knew how to do it. On the other hand, the silence could be interpreted to mean that there is no right, because that was part of the express and significantly litigated issue at the time in terms of what everyone was giving up to form a more perfect union. Whether the silence cuts in favor of a permanent union or a union that permits divorce is an open question in terms of the exact specific language of the Constitution. Second, we looked at the 10th Amendment, and we did a recap of various 10th Amendment cases to understand the power of the 10th Amendment and what its language means. We saw and listened to Justice O'Connor's battleground of federalism speech, or at least part of her speech, and we saw how federalism has shifted heavily over time as to whether the 10th Amendment is a declaratory truism or has some sort of substantive scope and power to it. On that front again, whether the 10th Amendment permits that as a reserved right, that is the right to secede, is itself a similar open question that can be debated on either side. Third, we looked at the 14th Amendment and the citizenship language and the privileges and immunities language, and that seems to provide the strongest textual argument, at least that the act of leaving would interfere with federal citizenship, which is defined by birth in a state, with federal citizenship being the supreme citizenship and state citizenship being derivative to that. But again, it is not expressed nor clear, and certainly does not say in surrounding documents that the point of those clauses was to deny a state the right to secede. We also looked at the Supreme Court and its decision, which had very, very clear language, obviously, that can be quoted to say that the act of leaving is unconstitutional. But at the same time, it is a decision that is 150 years old and existed in a world where consent was understood very differently to today. And as Erwin Chemerinsky and his book noted, there is other language that is not regularly cited or discussed by legal scholars, but which certainly offered a safety valve and gave the idea that by revolution or consent, then secession could be arguably legal. Ultimately, we also saw a variety of scholars who weighed in on this, including the professor from the University of Virginia, who wrote the book on the treason trial of Confederate President Davis, and how the United States government was very concerned about prosecuting him for treason, because it would open up the question of whether the secession was legal or not. And if they lost that, that is, the succession was deemed legal, then that could create more problems. That very concern of the government sits at 30,000 feet and shows that the question is not necessarily as clear as we may think. We also did a fun look at a couple of states who also have their own secession movements, from Alaska to Hawaii, and we saw the Alaska Supreme Court unequivocally deny the right to secede, citing to the Texas versus White case from 1861. And we saw, although not an act of secession, certainly an act of revolt by the state Supreme Court in Hawaii against the United States Supreme Court when respect to the Second Amendment jurisprudence. All in all, the issue has significant legal academics saying that is unclear and not a case-closed issue. And so with the public sentiment that we all see and hear about on occasion, and saw here in data, this is an issue that, as Erwin Chemerinsky said in his book, needs to be discussed and addressed more. And all in all, you have seen all the legal arguments on each side of the ledger. And so, now you must decide for yourself the best answer you think our Constitution gives to this question. Aloha to you all, and as always, if you have questions, please reach out.